Think your GPS is private? Supreme Court just said otherwise. It tracks your every move, logs your habits, and stores it all in a digital diary you never meant to write. Every app you install, weather, navigation, games, asks for your location, and most of us just tap allow without thinking. Companies collect and sell this data, turning your daily routine into a product for advertisers, data brokers, and sometimes law enforcement. You might think your movements are boring, but over time, they reveal your habits, relationships, and vulnerabilities. We trade privacy for convenience, clicking agree for faster pizza delivery, or easier directions. But what happens when someone wants to read your digital diary without your permission? When police come knocking, not on your door, but on Google's? That's exactly what just happened in Ohio, where a new court ruling could change the relationship between you, your phone, and the authorities. This isn't just about one case. It's about the future of privacy in a world where every step is tracked. This ruling creates a massive loophole. Police need a warrant for vague cell tower data, but not for the hyper-detailed app data that maps your life. So, by using apps and agreeing to location sharing, you've supposedly given up your Fourth Amendment protection for that data. The court relied on the third-party doctrine, a 1970s legal idea saying if you share info with a company, you lose privacy rights over it. That means police in Ohio can ask Google for your detailed movement history, no judge required. On July 2, 2025, the Ohio Supreme Court ruled that police don't need a warrant to get your location data from app providers. This all started with a stolen gun in Ohio. Police wanted to track a suspect's movements. Instead of old-school detective work, they subpoenaed Google for the suspect's precise location history, no warrant needed. The data was minute by minute, showing everywhere the suspect went, including a Lyft ride. Defense attorneys argued this was a clear Fourth Amendment violation. Continuous location history is private, and police should need a warrant. But the court had to decide if old rules about sharing info with companies applied to today's detailed app data. The result? A routine criminal case became a battleground for digital privacy, with implications for millions of people. The court's majority stuck to the third-party doctrine. If you share your location with an app, you can't expect privacy from the government. They argued that tapping allow on a pop-up is a voluntary agreement, so constitutional protections don't apply. It's a cold, contractual view, treating your location data like telling a bank teller how much cash you want. The dissent warned this gives the government a digital dragnet, mass surveillance with no judicial oversight. They argued sharing your location is often a coerced choice. You can't use modern services without it. This data reveals everything: your politics, religion, medical visits, and more. Their warning: privacy could become the exception, not the rule. The legal fight is far from over. Didn't the U.S. Supreme Court already say police need a warrant for location data? Sort of. In 2018, Carpenter v. United States required warrants for cell site data from carriers. But the Ohio court said app data is different. You voluntarily share it by clicking allow, unlike cell tower data, which is automatic. So police need a warrant for rough cell tower pings, but not for the pinpoint app data that shows your every move. This legal loophole means your rights depend on how your data is collected, not how private it actually is. If clicking a button means giving up your rights, privacy is on shaky ground. The law lags behind technology, but you can act today. Start with a permissions audit. Check which apps have location access and shut off any that don't absolutely need it. Turn off significant locations on iPhone, pause or delete location history on Android, and consider using a VPN. Courts move slowly, but legislatures can act now to close these loopholes. The Ohio decision is a wake-up call. Privacy isn't guaranteed. It's something we have to fight for. Every app, every setting, every law matters. The future of privacy is in your hands, literally. If you want every new privacy alert the second it drops, smash subscribe now and join the other right-savvy viewers. Stay informed, support privacy organizations, and tell your representatives you want digital privacy protected.